need to show that you have worked in Canada by virtue of a work permit or a work permit exemption, and that you intend to reside in Ontario or in Quebec, and that you have, most importantly, worked in direct patient care in the hospital, public or long-term care home, or an assistance facility. You've acquired minimum of 120 hours, which is equivalent to 4 weeks full-time work between March 13, 2020 and August 14, 2020. You also need to show no later than August 31st, 2021, that you've acquired a minimum of 6 months full-time total experience. That experience that you want to show must be paid for. It must be a paid employment. In other words, it's not an unpaid employment. And the government is also willing to consider any internship that you have done as part of a post-secondary study program. And importantly, as with all Canada's immigration requirements, you also need to show that you're not inadmissible to come into Canada. So these basically are the requirements. More detailed, it gets more detailed as we go into it. So at this point, I think we should start. Tosi, what do you think? We should start with questions, taking your questions.
Yeah. I see some questions have come in the chat box. I also see a message here from our media support, just to let everyone know that this session is being recorded. And so it's important that in asking your questions, you also bear in mind that there are other people who are on here. Some of the attendees, I can see names. So it's important that you bear in mind that this is technically a public forum. And so we keep questions as general as possible. Avoid discussing your personal matters on this forum so that we do not breach the confidentiality rules. Ultimately, our goal here is to provide information. We're not out to give legal advice. So it's just for information purposes to our community, our clients, as aware. So it's important that we're all on the same page with respect to these issues. But we're ready to go dealing with the question. So I'll try to take the first question that I see here. Right, so there's a question on here about somebody who may have worked as a cleaner in a hospital and who also made a claim before March, most likely worked through the first wave of the pandemic. And the question is whether or not that person qualifies. The policy that has been released, as well as the guidelines we have read so far, provide direction that the folks, the healthcare workers who are qualified for this program will be people who provided direct care. So except there is a job description where the person who worked as a cleaner was providing direct care to patients in any of those facilities that have been mentioned in the government's policy about this program, the simple answer will be it's unlikely that a cleaner is eligible for this program, except, like I said, the job description can show that some of the day-to-day activities of this cleaner fits into first any of the various NOC classification occupations that have been released. And if your reference letters, your employment letter can establish that what you do essentially is providing direct care to the patients in the facilities or in the hospital, as the case may be. In terms of the designated occupation, National Occupation Classification Codes, we have code 3011, 30112, 3233. 3011 is the nursing coordinator and supervisor. 3012, registered nurses, registered psychiatric nurses. We have 3233, licensed practical nurses. 3413, nurse aides, orderlies, patient service associates. We have 3124, allied primary health practitioners. And then there's the 4412 that encompasses home support workers, housekeepers, and related occupations. However, important to know that for NOC 4412, housekeepers and related occupations are excluded from the designated occupations under the policy. What this essentially means is for NOC 4412, the designated occupation that is permitted or that this program extends to will be the home support worker, home support workers. And so if your occupation doesn't fit into any of this category, going strictly by the terms of this policy will appear that such a person will not be qualified.
Thank you, Tosin. The next question I see up there is one about whether a child 18 years old, will a child 18-year-old fill a form personally, or such a child will feature on the parent's form? There's a cutoff age, I believe, is 22. So for someone who's 18 years old, a child who's 18 years old, that person would be a dependent on the principal applicant's in the principal applicant's form. So there are forms that the 18-year-old would have to fill along with the parent. A separate form that the 18-year-old will fill along with the parent, but the 18-year-old would be a dependent in the parent's application. I hope that answers the question. Unless the 18-year-old is the principal applicant, that is. If the principal applicant is the 18-year-old, then yes. But if he's a dependent of the parent, then he would fill the form under the parent. Not an individual form, but their package, part of the package includes forms for people 18 years old and above. There's another one. Will I still be eligible if I start the PSW job? Still, I did not work between March to August. I think from what we've read so far, if you didn't, if you're just going to start, then you wouldn't fit into, you won't meet the eligibility requirements. There are strict requirements that you have to meet between March and August, 120 hours to be able to apply.
Okay, so the next question here says, can you explain in detail the inadmissibility or credibility issue for the pathway? First, I'll start with credibility. I think I'm going to need some context for what you mean by credibility with respect to the issue of pathway. My reading of the policy, and I wouldn't mind being pointed to which part of the policies or policy documents speaks about credibility. But ultimately, for credibility, I would assume that this will relate to the information you are providing. Ultimately, the information you provide in support of your permanent resident application, whether it's even in the case of your refugee claim, ultimately has to be credible. But one isn't looking in the context of this PR policy, the credibility of the refugee claim that you had made. Where you need to be credible is in terms of the information that you provide in support of your PR application. For example, your biodata information, your employment history for the past 10 years, your address history, all those things have to be credible. The family members who you disclosed, information about whether or not you've been refused visas to other countries or you made refugee claims elsewhere, all of that information will need to be credible if that's the scope of what this means. So if a person provides information that is discovered to be false, or you withhold information that is relevant and material to the determination of your eligibility for the program, your eligibility for permanent residence in Canada, it could ultimately lead to what we call misrepresentation, and misrepresentation could ultimately lead to inadmissibility that you had asked. So just segueing into what admissibility will relate to, admissibility generally is a concept whereby anybody who is getting status in Canada, whether as a temporary resident or permanent resident, has to be admissible to Canada. In simple terms, does Canada's laws permit you to remain and reside in Canada? Have you done anything that contradicts Canada's laws with respect to admissibility? A person could be inadmissible to Canada for a number of reasons, such as criminality, not coming into Canada with the necessary documents before you arrive, issues about medical inadmissibility, where you have a medical condition that would represent a strain on Canada's healthcare system, financial inadmissibility, a person who is, for example, moving to Canada as an economic immigrant. The person needs to be able to show that he has the financial capacity to, first of all, take care of his needs in Canada. Among other things I've talked about, there are also security concerns. If your presence in Canada will be a public safety issue, put the lives of Canadians and other permanent residents, temporary residents who reside in Canada in danger. All of these things raise admissibility flags for which a person may, or which the immigration authorities could make a determination that that person is not admissible to Canada. So in a general sense, that's what admissibility is. However, for this pathway program, the government has sort of made certain exemptions that will sort of apply to folks who would otherwise be inadmissible to Canada. For example, having failed to comply with conditions of a temporary stay. For example, you overstayed a visiting visa, your visitor's record, or your work permit. Many times people who are in Canada as temporary residents eventually may have some reason because of the risk to their life to have overstayed in Canada and eventually made a claim. In that kind of situation, that could raise an admissibility flag. But in this program, that admissibility issue is being exempted. There's also the issue of working in Canada without authorization. That could also lead to an admissibility concern. If you have entered Canada, as many refugee claimants would have, without the required visa or documents required by Canada's immigration regulations, you ordinarily be inadmissible to Canada. But this public policy makes exemptions to those things that I talked about. But the other things about criminality, for example, and I find that many people in Canada may not be aware, issues of criminality, serious criminality. So if you're charged in Canada for a crime, you eventually get convicted. It could result in admissibility for you. Or for example, a person does the simple thing as that's called impaired driving in Canada, driving under the influence of alcohol. That could raise a serious criminality issue if you eventually get convicted. All of those things could raise admissibility flags. And so it's important that even though certain things have been exempted for admissibility as far as this public policy is concerned, you still remain careful to ensure that you're still ticking off the boxes as far as admissibility is concerned. And another thing to be wary of is the financial admissibility to Canada. There's no specific exemption provided under this program. And so that could raise a flag where a person who is putting forward an application to be eligible for this program is determined not to be financially independent. For example, you're still dependent on welfare, provincial welfare, as the case may be. That could raise a concern in the mind of immigration authorities to say that this person who is seeking permanent residence is otherwise financially inadmissible. So in a general sense, those are the things that one would think about when you talk about admissibility to Canada.
Thank you, Tosin. There's a question here about whether the program covers personal caregiver to an 85-year-old woman on one-on-one. I want to interpret the one-on-one. I'm not very clear what the one-on-one means, but if you mean that you're self-employed, then you will not be covered under the pathway, because one of the requirements is that those who will not qualify are those who are self-employed caregiver, those who are employed by private households, directly employed by the person receiving care, or by the family of the person receiving care. And then those who are only doing the primary duties of the housekeeper, which we've already mentioned before. If it's just cleaning and it has nothing to do with direct patient care, then that person would not qualify. So if the interpretation of one-on-one relates to who the employer is, in the sense that you're employed by the 85-year-old woman directly or by her family, there is no agency involved, there is no long-term care home involved, then you will not be eligible. But if you mean, I can't even find any other meaning. Tosin, do you see any other meaning to the one-on-one? Unless
that's my interpretation of it as well. This person appears to be privately employed and is providing this care to the 85-year-old woman. The public policy seems to exempt that person or exclude that person from this program.
The exclusions are, well, there's a balance somehow. There are lots of exclusions and there are lots of inclusions. You need someone to, most likely need a lawyer to sift through and let you know if you qualify or not. And sometimes it will depend on the job description that you have as well. We need to see what you have in terms of letter of employment and who the employer is before we can categorically say that you're not eligible. But if it is strictly you were employed by this person one-on-one, to use your term, then you will not be eligible. For security guards, again, I'll just read one of the NOCs that are eligible to apply. The closest to security guard that I can see is the NOC 4313, but unfortunately it's limited to non-commissioned ranks of the Canadian Armed Forces. So I know that at one point, Canadian security officials were assigned to long-term care homes to provide care. And it looks as if all the government has done so far is to make these people eligible. But as it is, if it is just a security official at the door, you did not provide direct patient care, then you may not be eligible, fortunately.
Okay, so this question, I'm going to phrase it in a general sense. A person who works as a personal support worker but did not work during the pandemic because the person was pregnant and delivered of a baby at some point in that period. The person had a sick leave from the doctor and is presently on maternity leave. Would the person qualify? So one of the, to my mind, compulsory requirements is for a person to have worked at least a period of 120 hours in this period. There are certain exemptions which have been provided, particularly with respect to that 120 hours, and that relates to a person who contracted COVID and was unable to work during that period. The policy provides the periods of paid or unpaid sick leave may be counted when assessing the 120 hours or 6 months experience requirement if the applicant contracted COVID-19. So with respect to the 120 hours, if you contracted COVID-19 and it's the reason why you were unable to work and proceeded on sick leave, then you can use that period towards your 120 hours. You can also use it towards the 6 month experience. The policy goes forward to say period of paid or unpaid leave during due to illness or disability, maternity or parental leave, quarantine or isolation requirements due to COVID-19, caring for family who contracted COVID-19, or lack of childcare due to COVID-19 may be counted when assessing the 6 month experience requirement. So there's a slight difference here. If a person contracted COVID-19, you could use that as to satisfy the 120 hours requirement. But the other categories where people had been unable to work, for example, the maternity leave, quarantine or isolation and all of that, can only help you towards satisfying your 6 months requirement. So there's that difference. I would also like to point out the fact that for the rest of Canada, there's a difference between the policy that applies to the rest of Canada as against Quebec. I'll get to Quebec shortly. But essentially what I mean here is, if a person is unable to work simply because of being on maternity leave, the policy doesn't seem to give you a leeway with respect to your 120 hours. The leeway you get is towards your 6 months experience. So say, for example, a person who was delivered of a child in, say, June, or for example, May, but worked between March and April, there's a strong possibility that that person may have gotten up to 120 hours. But if for any reason you hadn't gotten up to 120 hours in that period, it becomes dicey as to whether or not you are on the face of it eligible. However, for Quebec provides the exemption to extend to a person who was asked to not work because of preventive measures. So if the reason why you were unable to work while you were pregnant was your doctor determined that it's unsafe for you to be in the work environment where you're prone to contracting COVID, and provided you documentary basis to stay off work for preventive measures, then you'll be able to use that period to satisfy your 120 hours. So to be clear, the only reason why your 120 hours may not be complete and you will still be eligible for this program will be if the reason why is you contracted COVID and were unable to work. The other things would go towards your 6 months experience.
Thank you, Tosin. Let's see what we have again here in terms of questions. we've already done the one about sick leave. Okay, this one comes in, can someone who has not gone for hearing be eligible for the pathway? I would say it depends. We already mentioned that a pending or a failed refugee claimant can apply, provided that they made a refugee claim in Canada before March 13, 2020, and they still live in Canada. So if you still live in Canada, you made your refugee claim before March 13, 2020, whether your claim is pending or it's been refused, you are still eligible to apply, provided your claim was made before March 13, 2020.
Okay,
you
done?
want to add something to that?
Oh, no.
Okay, go ahead. Go ahead.
So I was just going to jump up to the next question, but if you're still on it, I can hold off. Okay, so I'm just going to go ahead.
Go on.
Right, thank you. Okay, so if starting a PSW job from now, how many hours should we meet before being, I imagine this person means to say eligible for before August 2021. So essentially, if you already had the 120 hours for between March and August, you would need to add about, where's my maths? About 630 hours more to get to about 750, which is the 6 months requirement threshold. A person working full-time, 30 hours a week, 30 hours a week, 4 weeks a month would need to get to 720, but to be safe, because the policy says 750, I would say it's better for you to get up to 750 to show your 6 months. But if it's the case that a person is just getting licensed as a PSW, is just getting a job and have no work experience before between March and August, again, this requirement says that you must have that 120 hours between March and August. So again, like Anya had said earlier, it may be helpful for you to get before a professional, provide your documents, let's see what's in it before we can make a decision one way or the other, or advise you one way or the other as to whether or not you are still eligible for this program. But bear in mind, the 120 requirement is a mandatory requirement. Okay, so this person says, I get the message. We'll try to break it down.
Follow-up question. Okay, go ahead.
Right. I was just laughing about the use grammar way we fit understand.
Exactly.
We get your message. We'll make it simpler going forward.
So you're using too big grammar for.
I'm sorry. Yeah, we'll tone you down.
We'll tone it down. But the next question is actually a follow-up to the one you just responded to, asking whether 6 months experience is from March 13, 2020 or before that time. I believe it's from March 13, 2020. Please correct if my
6 month experience from March 13, 20. Well, I mean, my view is that the policy doesn't exactly limit where you're getting your 6 months experience from to March and August. So a person who say has been working as a personal support worker or nurse aide from January 2019, the person probably already has 120 hours before. Or yeah, you likely already have 6 months worth of experience. Sorry, 6 months worth of experience, what I meant to say, instead of 120 hours. So there's no limitation. There's no, what's the word? Time frame where you must have started your 6 months experience. The time frame just says that you must have gotten that 6 months experience before August 31, 2021. And so your application must be in, and you have up until October 30th, 2021 to show proof of that 6 months experience. So if you already have it before March, all well and good. If you have it after, you can put in your application. When the 6 months is complete, then you provide proof of the 6 months experience that you have gathered so far. There's a question here that talks about, does a homeless shelter worker qualify for this? My response will be that it depends on what that homeless shelter worker is doing exactly, and whether or not your national occupation classification fits into the designated occupations So designated occupation basically means the occupations that have been identified. The occupations the government has said, these are the people we want this program to apply to. So if a homeless shelter worker is, for example, can be defined, your job description can be defined under a home support worker, yes, you will qualify. If you can be defined as a nurse aide, yes, you will qualify. And that's why we have been saying to our clients that it's important that your employer is able to identify in their reference letters to say, this job description you are employed for is in this occupational classification. It's in this category. That makes your life easier. It makes you credible as against doing it yourself to show what it is you do. If your employer is unwilling to do that, and I found some situations like that, you can always show based on your employment letter, your resume, that this work that I do, it fits into this category. And that's where a professional's help comes in being able to show from your documents how you qualify for the requirements of the program.
So there's a question about how to, I think I missed it. How to demonstrate your experience, how to show proof of your experience.
Hours of work.
Let me see if it's limited to 120 hours or where is it? Well, either way, whether you're trying to show your 120 hours, yeah, it actually, the question is tied to the 120 hours. What's the proof for the 120 hours? So based on the guideline that we see from IRCC, you would need to provide reference letters, and preferably it should be on the company's letterhead. Whether it's the employer or the agency that you're working with, it should show the period of work that you've referenced in your application. So it shouldn't be different from what they're saying in their letter, shouldn't be different from what you are saying on the face of your application. So you need a reference letter from your employer. I would want to delve a little bit into what your reference letter should say specifically, and importantly, it should talk about your NOC, that's your National Occupation Classification Code, one of the ones that we've mentioned before. It must, if it's not within those NOCs, then it may not be helpful. The reference letter would not be helpful. It should describe your employer's business. It should state your main responsibilities and duties, the number of hours that you've worked per week. So if the reference letter tells the number of hours that you've worked per week, and it tells how long you have held that employment, that naturally would, it would help confirm how many hours that you have done. It should state a specific period of your employment or internship for those that are relying on internship. Then you should be able to show your pay slips as well. Your pay stubs will be helpful in showing how many, for some people, their pay stubs actually reflect how many hours that they have done to date. I think that's about it for documents that you can show. You can also show your letter of employment. That's also very important. Your letter of employment would show that you're employed, but it may not say how many hours that you have done. But most importantly, I think the reference letter, an updated reference letter would do the job for you with your payslips.
Okay, so I'm going to sort of give a stab at 3 questions together. I think that they sort of relate to the same thing. One talks about, or is asking to speak more about internship. Another is asking about a person who was on a PSW program and started work late August. Is the person eligible? A question also about somebody who was in college and wasn't able to work or get work due to being pregnant. Is that person eligible? So with respect to internship, the requirement for your 120 hours is that your 120 hours should be paid. But there's the exception that if a person who was doing an internship in a post-secondary program or a vocational training and was required to do that internship, that person would likely have worked unpaid. That work experience will be eligible. So that's where internship comes in. It exempts you from the requirement to show that you were paid for the 120 hours, particularly if you were doing it in furtherance of your internship or in satisfaction of your requirement to get your license to either be a personal support worker, a nurse, or whatever it is you needed to do to fit into any of the selected occupations, right? So if that's your case, you likely will be eligible, regardless of whether or not you got paid. The question again about a person who started work in late August, I assume my interpretation of late August would be late August is the second half of the month. So say between 15th and 31st of August. The program cutoff for 120 hours is August 14th. So if a person started work like an employment, a paid role late August, that employment will go towards your 6 months experience. But I would assume that a person who was doing a certificate program may have gathered internship hours prior to late August where you got employment. So if that's the case, that internship hours the internship hours that you have, maybe you need to get a letter from the school, the place you were posted to, for them to confirm the experience that you had during the period, your resume and things like that. All of that will help you towards satisfying your 120 hours. So that's how it is, I think, with respect to internship. Again, we had addressed the issue about the pregnancy. My response again would depend on which province you are in first. If you are in Quebec, you weren't able to work as a preventive measure because of this pregnancy that you had, then that's awesome. But if you're in the rest of Canada, you weren't able to work because of your pregnancy, the only thing that will help you is towards your 6 month experience. The 120-hour requirement, that exemption that is provided in the policy is not extended with respect to that.
Okay, so I've seen questions asking for the NOC classifications that are eligible, and I put that in the chat. You would see, I think Tosi mentioned it before already, but now you have it in the chat. You can check it online. It's online and it's available to everyone who's curious to know. I've seen one other question here about whether a DSW is a qualified NOC, Development Support Worker. Now you need to check each one of the NOCs to be able to confirm that. But I think the closest NOC for a disability support worker will be the 4412, because reading that NOC, it shows that examples of such titles, you have attendant for persons with disabilities, home care, family caregiver, home support worker, housekeeper, living caregiver for seniors, personal aid, home support, personal care attendant, home care, respite worker, home support. So these are the titles that fall under home support worker. And I think a disability support worker should fall under the first one, which is attendant for persons with disabilities. So the core, more importantly, what is more important with respect to eligibility is whether you provided direct care to the patient at that time or those in the home at that time. You have to show for home support worker, and I believe the disability support worker would fit into that as well, that you provided care and companionship for individuals and families, administered bedside and personal care to clients, you prepared their meals, you performed routine health-related duties, including changing dressings, assisting with medications and all that, and sometimes performing routine housekeeping duties. So those, I believe that a disability support worker would fit into that 4412. But again, it depends on whether your employer says that in your reference letter. It has to be specific, outlining the specific duties that you carried out during the period. That's it.
Okay, so let's see, what was that question from? Please explain the So the explanation appears to say this opportunity is open until August 2021 with 6 months caregiver experience. Well, I mean, that's what the policy says, that you have up until August 2021 to provide your proof of 6 months experience. But there's also another part of the policy that says that this program is open till, yes, August 2021, or till when the minister revokes the public policy, right? So there's that discretionary power that the minister would have. But I would expect that if people really do have up until August 2021 to show their experience, it is unlikely that the government will pull the program beforehand. But again, one can't say that for certain. It could be revoked beforehand, while people who had submitted still have until the period to provide their 6 months experience. So what a person needs to do quickly. The rules here are that if you already had the 120 hours, but you don't have the 6 months experience, you can put in your application and wait till you have your 6 months to show that experience. So if you already meet that first requirement, there really isn't a reason why a person isn't already working towards at least having your application locked in by the government, and not risking the possibility that it may be cancelled before you get your papers in. So that's how I react to that.
Okay. With respect to a PSW nursing or nursing coordinators, whether they are eligible. For nursing coordinators, there's actually an NOC, I believe, that covers nursing coordinators.
Yep.
There's
it's
a specific NOC 3011 that covers nursing coordinators and supervisors. But again, the titles that come under this, you would see nursing care coordinator, nursing services coordinator, nursing supervisor, patient care coordinator, nursing, psychiatric nursing supervisor, public health nursing supervisor. So please go online, check the NOC code to see the main duties of nursing coordinators. I may just quickly run through it. You supervise registered nurses, licensed practical nurses, and other nursing personnel. You evaluate patients' needs and ensure that required nursing care is delivered. You set up and coordinate nursing services in conjunction with other health services. You ensure quality nursing care is provided and appropriate administrative procedures are followed. You assist in the establishment of unit policies and procedures, and so on and so forth. It can also provide direct patient care. So those are the main duties of nursing coordinators and supervisors. So if your job classification or main job duties fall into align with this, then yes, you would qualify.
Okay, so there's this question here that says, what are the things to take cognizance of when merging an already existing H&C application with a pathway application? So I believe the appropriate word here is transferring. The policies, the guidelines for this program makes it possible for a person who already has an existing humanitarian and compassionate application for permanent residence to make a request to move that H&C application to the pathway program if you're eligible. One of the things to take cognizance of is how you are eligible for this program. So the documents that you would have had to provide if you were originally putting your PR application forward under the pathway, it's important to provide those documents. If you already provided those documents in the context of an H&C application, you can always make reference to that, or even just for making the officer's life easier. Again, officers are human beings, right? If we make their lives easier, they're happier when they're making a decision on your application, rather than asking them to go search your other application to find it. It's their job to do, but it probably makes their life easier if you have those documents sent in again. So the reference letters, your pay stub, those things, the new additional forms that have been provided in the context of this pathway program, that form needs to be provided. So you had filled your agency application, you fill the generic application form, a family information Schedule A form. The Schedule 1 form, which is an additional form in this pathway program, is not there. You need to complete that. You need to have a request where you're saying, oh, I am eligible for this program. I want my existing application to be moved. If you already know the application number, you put the application number, and you outline how you perceive for yourself that you are qualified, the new documents you're providing, the existing documents you already had in your application, you're making reference to that, and you sort of tie everything together to make, like I said at the beginning, the officer's life easier in understanding this is me, and this is how I had provided care during COVID-19. this is my 6 months experience, these are my kids' school records, those sort of things, and my application is strong and good to go. So those, in a general sense, are the things I think you need to be aware of while migrating or transferring or merging, whichever word we choose to use, your H&C application with the Pathway program.
Thank you. Here, I think, okay, there's a question here about the possibilities that the government will extend the same policy to those that worked during the second wave. I recall that when the announcement first came out back in August, all we knew was that if you were a refugee or failed refugee, you filed your claim before March, that you could apply. And I see now with the guidelines recently provided that those who lost families to maybe a family member died during COVID, the family member that worked in long-term care home died during COVID, that families of such people can apply for permanent residence. That wasn't there initially. I say that not to say that, I say that, well, to say that there's a possibility, but I cannot say what if that would happen. I cannot guarantee that it will happen, but all I know is that when it was initially announced, it did not cover, they didn't make any provision for those whose family member died, worked during COVID and died as a result of COVID. So who knows? We cannot just only hope. Any other one?
Oh, my bad. I was muted. Someone's asking about 120 hours between November and December 2020. Again, as of this moment, the 120 hours is limited between March and August. So on the face of it, November and December 2020, that's a no. Again, like Irene said, no one knows whether or not the scope of this pathway will be extended, particularly considering the fact that the country is dealing with a second wave at the moment. So it's not impossible that the government may feel compelled to do it, but at the moment, these are what the rules say, and so we can only speak to what has already been put out. So November, December 2020, the answer is no.
I believe the same answer would also apply to those that just want to start working next year. No, you will not be eligible unless a miracle happens. There's a shift in the policy. You will not be eligible. Any other questions? I don't see any other
Right.
ones.
So I see one here that PR forms to be filled for -2 or only for the family, and will additional family information suffice for them? So the additional family information form, it's only for applicants who are 18 and above. So, for example, if a mother is the principal applicant, father, kids, one of the kids is, say, 19 or 20, that kid would also need to fill the additional family information form. The husband, who is likely already above 18 as well, the mother would also need to fill additional family information form. So, in terms of minors filling additional family information form, the answer to that is no. It's only for dependent children between 18 and 22 that will be required to fill the additional family information form. For the other application forms, the minor applicants will be listed as applicants under the general application form, the generic application form rather, and will be ticked off as applicants who would accompany the principal applicants to Canada to be considered an applicant in the process. This just also makes me talk about the issue of whether a person can list family members who are not in Canada. In terms of being an applicant, the policy makes it possible for a person who is eligible to include family members in Canada as applicants. But because as part of the admissibility check you would need to go through, if you have family members who are not in Canada, it's important that you also list them, but those applicants cannot be ticked off as applicants who are accompanying you to Canada at the moment, because as the policy provides, those applicants will not be eligible under this program. But for your admissibility examination, it's important that you do so. And the policy also even states clear that for family members who are not in Canada, you will be able to sponsor those family members who you can sponsor after you attain your permanent resident application status.
Thank you, Tosin. Will school results for the kids be good enough to show their school records? I think I believe that would be the best evidence of the record of their education in Canada. Yes. So if you have the school records, that should be sufficient. I can't imagine what else you can submit as proof of Canadian education. Yeah. So school results will be fine.
Okay, so next question is, see here, what if the kid just turned 18 this month? If the kid just turned 18 this month, before you put in your application, additional family information and the background declaration form will have to be completed for that kid. The background declaration form will be from 18 years till date or 10 years ago, whichever is more recent. So for a kid who just turned 18, you're dealing with just from 18, when he turned 18 till now. So people who already have an HNC application, would they need to pay the government application fee to transfer the existing application? My reading of the policy and the guidelines that we provided so far is that's no. You already made the application payments or the PR processing fee in your HNC application. You're just simply applying to move the application across. But again, if like I said, the policy doesn't say you have to pay again because you already paid. So it's unlikely to be the case, but if the government determines that you need to pay, a notification for that will be sent to you once your application is submitted.
Let me jump on the next one. Whether the PR pathway program, with the PR pathway program, how long does it take to get your PR? Again, the guideline release doesn't give it a new pathway program. We haven't done this before. So there's no indication of the timeline, how long it will take for you to get your PR. But we know that PR applications for protected persons usually take about a year, about 12 months. So yeah, that's it.
Just to add to that again, I think this may be a good spin to put into it. This public policy was made pursuant to Section 25.2. So that's a provision of the Immigration and Refugee Protection Act in Canada. So technically, this is like a humanitarian and compassionate application, technically. So if we also look at how long it takes to process a humanitarian and compassionate application, estimated timelines is somewhere around 31 months to complete the whole process. But like I already said, the government puts out processing time based on how long it took them to process applications that they've already done. And because this is new, it will probably need to see how the system deals with it, how fast the government puts it along. But also bear in mind that we're dealing with a pandemic at the moment. The IRCC's operating system is sort of changed to adapt to current realities. So it may not exactly be fast, but what is good about being eligible for this program is while a person is eligible, whether it's the CBSA, for example, a failed refugee claimant who is removal ready, the provisions here with that you will not be removed till a decision is made one way or the other. So I would say do not focus on how long it will take, but focus on putting your best foot forward to ensure that regardless of how long it takes, you're there smiling at the end of the process.
Thank you, Tosin. That's a very, very important tip there. Next question. You've left the organization for another, but you've worked between April 2020 and October 2020, and you already have your 120 hours. How do you get a reference letter from the company that you have left? That's not a problem. You just need your lawyer to give consent to your lawyer to write your former employer, and they should respond to your lawyer's letter if they don't respond to you. I think we've already answered that.
Exactly. Ideally, the employer should respond to you. I mean, I was discussing this in the office. I believe this was yesterday. It's not proper for an employer to say, "Oh, well, you left my employment. I can't give you a reference letter anymore." There's just something wrong with that. But if you do experience that challenge, that's where dealing with professionals assisting you in your application comes in. You can always sign a consent to get the lawyer, immigration consultant, as the case may be, to talk to this for my employer. So please, can you throw more light on who cannot apply in respect of their refugee claim, determined to be ineligible to be referred, withdrawn, or abandoned, determined to be manifestly unfounded and with no credible basis? Okay, so certain people who may have failed as refugee claimants have been determined not to be eligible for this program are sort of excluded, and you already laid that out. So I'm going to start with the first one. For a person who was determined not to be ineligible to be referred to the Immigration and Refugee Board. So let's take a picture back to when you made a refugee claim, and I'll deal with two scenarios. An inland refugee claimant. An inland refugee claimant is a person who was already in Canada, had some status, decided to make a refugee claim, and then went either to the IRCC office or the CBSA to make a refugee claim. A port of entry refugee claimant is somebody who arrived Canada and at the point of entering Canada indicated their interest in making a refugee claim. Either way, that person would have met with or would have done what is called an eligibility interview, either with a CBSA officer or whether it was at the IRCC office. You would have met with somebody who would first of all ask you questions about why you're in Canada making a refugee claim and things like that. If that person concludes that the reason why you have told that person during that eligibility interview is not sufficient to be referred to the refugee board, it means that your case did not get before the IRB. You likely did not have to fill what is called the basis of claim form. In that kind of case, that person would probably have been given a prior application, a removal risk assessment application at the time. In that case, that person's case wasn't referred, it was deemed ineligible at the time. If that's your case, you probably have received a document for it, and you know that that's your category. So strictly speaking, the person did not eventually become a refugee claimant, strictly speaking. So that's one category. That kind of person who did not make it to the refugee board is ineligible. A person who did make a claim, but decided to withdraw it. So I decided that, you know what, I made my refugee claim, but I want to go home. You withdraw your refugee claim voluntarily, that person is not eligible for this pathway program. Or you fail to do something at the time you ought to have done it. For example, you fail to provide your basis of claim form within the 15 days you were provided to do that, or you fail to show up at a hearing, and as a result of that, the refugee board determined your claim to have been abandoned. Or you filed an appeal, you not go through with it, it was deemed to be abandoned and stuff like that. That will be that category in terms of withdrawn and abandoned. A person who was determined to be manifestly unfounded or with no credible basis. So manifestly unfounded means that the evidence you provided or the testimony you provided at your hearing has no bearing with why you say you are afraid. It was determined to be completely untrue. That's different from a person who was determined not to be a conventional refugee and credibility was the determinative issue. That's a different thing from manifestly unfounded, no credible basis at all. Like, say, for example, I say that my life is in danger in Nigeria because I'm a member of the LGBT group, and as a result of that, the laws in Nigeria sort of persecute me and like that. But at the hearing, I started talking about something completely different that has no correlation with the provisions of the law as to why you can be determined to be a protected person or a conventional refugee or a person in need of protection. The refugee board came to a conclusion in your decision that said your claim is manifestly unfounded, you had no credible basis, then that person is not eligible for this program. Such kind of people would not have had a right of appeal to the Refugee Appeal Division. Such kind of people would only have had an opportunity to seek a judicial review at the federal courts. So if that is your situation, then this program doesn't apply to you. Another category to bear in mind are folks who may have been referred to the refugee board, but for some reason or the other, maybe because of your conduct in Canada, your claim was then determined to either have been suspended and eventually pulled back from the referral. So CBSA says that they're pulling back your referral to the refugee board initially, then this program will not apply to you. Or they say that because of your conduct prior to coming to Canada, they had come to a final determination. So I mentioned the suspension of your hearing. If your hearing is suspended until the final determination is made that your initial referral to the refugee board has been pulled back, then you will still be eligible for this program. So if you're somewhere in between that phase, this program will apply to you. But if that final determination has been made, say for example, you dealt with an issue of impaired driving, and because of that, your refugee claim was deemed not to be eligible for a referral, then this program will not apply to you. So that in a sense, in breaking it down simply, is what this exclusion of certain people will be.
Thank you very much, Tosi. With respect to professional fees, please shoot us an email, info@TPM Attorneys, and we'll be happy to respond. For the question, whether your employment letter that explains what you do as a caregiver is sufficient, we've already gone through what your reference letter should say. Whether it's employment letter, whether employment, I don't know what, maybe by the employment letter you mean the reference letter, but if that's what you're saying, we've already explained what it should contain. Specifically, it should mention the NOC under which you're being engaged, and it should describe these main duties and other duties that you perform. So again, it will depend on the lawyer that is reviewing your file, whether that's employment letter is sufficient for the purpose for which it's required. There's another one. Let me see if there's any other one. We're running out of time. Is whether the pathway program is online or paper-based. It's paper-based. It's not online. Can the hours accrued for volunteering duties for a qualified job count for the 120 hours? Like we already explained at the beginning, it has to be paid employment. So volunteering duties would not, may not qualify. I
mean, that would be except that volunteering was done, for example, as an internship. If what you mean as a volunteering it can be defined as an internship, i.e. in a post-secondary education, part of the requirements of a post-secondary education or vocational training, then there's hope for that.
So this question about whether the documents you submit now must be the same documents, I don't know, talking about back home documents, I'm not very clear what you mean by that. Talking about back home documents you submit now, must it be the same documents you must submit now?
Okay, so I just to take a guess here, this person may be talking about documents you may have submitted in the context of your refugee claim. Must it be the same documents you submit now? So before I talk about documents, I just want to deal with information. For information, it's important that your information is consistent. With what you have provided in your immigration forms, in your refugee claim. The difference here is certain things you may have said that CBSA would have overlooked when processing your original refugee claim. The IRCC may not overlook that. And just one example, I know many clients do in their background declaration form, just say employed, where they're talking about their personal history, or just simply say student. This policy says that you must be specific about what you mean by employed. So if you're employed as a personal assistant, please state that. If you're employed as a school teacher, please say that. If you're employed as a lawyer, please say that. So to that extent, there must be consistency. In terms of the documents that you had submitted, must it be the same documents now in this PR pathway? For any document that is relevant to this process, I know that prior to the announcement of this program, certain clients had provided documents about their work experience, whether in the context of a pending RPD hearing or a refugee appeal. Those documents may be relevant to showing that you fit or you qualify for, you're eligible for this program, right? Those documents can also be submitted. But in terms of your back home documents, they are not, so I imagine you're talking about your credentials from back home and things like that. While they are not essential requirements for this program, I honestly see no harm in putting it in. Say, for example, your BSc degree and things like that. You may put it in, but those things are sort of surplusages. The main requirement will be what experience you gathered here, the job you have done, the 6 months experience and things like that.
Okay, say for example, if you've submitted a birth certificate for yourself and you probably have a new one now, a different one now, like Tosi has already said, it has to be consistent with what you have submitted before. It can't be different. I'm just using that as an example of documents submitted before that has to be the same as what you're submitting now, unless it is an updated version. If you say, for example, you've submitted, I can't even think of something right now that, unless it's an updated version of what you submitted before, it's an update, yeah, that would be fine. But if it is to change what you have submitted before, that may not be very helpful for the sake of consistency and credibility. Whether you can move to another province after submitting your application, I believe the reason why they're asking for the province of your choice is so that they would know exactly where you're looking to move to. So if you put in the application and you move to another province, I don't know how that would affect. I can't see right now how it will affect your.
I mean, for the rest of Canada, I don't think it will. So, say for example, a person puts the application in Ontario, yeah, and you move to Manitoba. Yeah, that's Manitoba. Yeah.
Quebec.
So you move to Manitoba. That's still fine. But if you then move to Quebec, and your application indicates that you intend to reside in Quebec, there's different rules that will apply. You'll probably be looking at the Quebec rules being applied to your application. But if your application already says that you intend to permanently reside in this part of the country, I believe that the rules that apply to that part will be what applies to you.
So this next question has to do with a child that was mentioned on the refugee claimant form, who is now married and pregnant, whether that person can still be included in this for inadmissibility case. First, like Tosi had already mentioned, first, only those that are here in Canada at this time are eligible to apply, but that there's still the requirement that you include all your family members that are back home, so that if you intend to sponsor them at a later time, there will be no issues. I don't see any reference to the age of this child that we're referring to, but that may also be an important consideration in responding to this question. Josie.
Okay, so for that question, here's what I wanted to say with respect to that. A child who is married definitely can no longer be a dependent child. But in terms of sorry? Yeah, but if, yeah, so as I recall it, the rules with respect to a dependent child has to be one who is
not married.
Is not married. So a child who is 19 and has been married can no longer be considered a dependent child. And I believe that's my recollection of that. But where I was going is this child is still a child of the applicant and will need to be mentioned in the family information form, whether or not the person is married. So that is the only place where I see this child coming in and being for an assessment of your admissibility to Canada. If you do not disclose that child and they find out that you had that child, it could be a problem for misrepresentation. Okay, so this is sent to me personally.
While you're looking, let me take the next one.
We dealt with this question about somebody who's been in school, just graduating, being eligible for this program, for this program.
There's one question about the chance of being denied with this program. Well, it will depend on whether there are inadmissibility issues or credibility issues. But I think those are the two major considerations, and whether you indeed meet the requirements of the program in terms of eligibility requirements, the 120 hours, the 6 months, those would be the reasons for refusal. So the chance of being successful is very high, and the chance of being denied is also
very high.
at the same level, depending on
how your application
that
is
we
put
talked
forward.
about. Exactly.
Yeah. So, I mean, ultimately, the discretion lies with the officer who is acting on behalf of the minister. That you put in an application doesn't mean you will be granted. So, care needs to be taken to ensure that you're able to check off all the boxes and check it off properly to reduce the chances of being denied, so to say. Is IELTS needed in this pathway? The answer to that is no. None of the requirements put out so far puts IELTS as a requirement. So is H&C eligible? Again, I read this to mean that what H&C, how H&C plays in with this application is if you have an existing application, you can move it to this application if you are eligible. So H&C is not an eligibility requirement for this, but it's the other way around. But if you don't qualify for this program and you are eligible at the point where you can file an H&C application, maybe because of the things you have done in healthcare, but the policy as it is today doesn't extend to you, you can put in an H&C application and make your Canadian interest case, the work you're doing and things like that on a compassionate basis and see how that plays out with the officer. If all you submitted before was a high school diploma.
That's a clarification on the previous question about submitting, whether you can submit documents you've submitted. You are bound to submit documents that you have submitted before. So this person is letting us know now that it's an updated, like you have a better credential. What you submitted before was a high school diploma. Now you have a university degree. Yes, you can. Yeah. And submit your completed university degree. Police report.
Okay, so for police report, the requirements laid out in the guideline doesn't make a police report a requirement, whether in Canada and all or outside of Canada at this stage. But again, the indications we see from the policy is that it is likely that that may be required at the final stage of the process. So just like an H&C application, even though you submit a police report at the beginning, the police report is only reviewed when you get to your stage 2 of the process, or reviewed more closely, as the case may be, when you get to stage 2 of the process. So that a person has been away from Canada for 2 years doesn't mean that the officer in finalizing the application may not be concerned about checking your admissibility based on what your records will show in Nigeria. The officer may at that point require you to produce it. But again, considering the fact that refugee claimants are people who are fleeing from particular countries, so it is likely that officers will be careful about asking you to provide police reports for countries where your life seems to be in danger. But we will see how the government deals with that. But at the moment, that's not one of the requirements to submit your application for this program. So let's see. Okay, so I think that we sort of covered the questions that are here. This last question talks about, please talk more about, make clear more about credibility. Again, like I said at the beginning, how credibility fits into this process is the information you are providing in support of your application must be truthful. Background checks will be done. The scrutiny will be higher than what may have been done at the time you made your refugee claim. So travel histories will be checked. Records that are maintained of you in other countries will be checked that Canada shares information with. The information you provide may be verified. Your employers may be contacted, particularly the employments in Canada. So not just providing the reference letters, it doesn't do all the work. Part of the policy is that officers have the discretion to decide to make additional efforts to verify, investigate the information you provide. So it's possible that your employer, the HR department of your organization may be called to say, oh, we have this reference letter from so person. Do you have any records of that person? So it's important that your information is consistent, your information is true, and the documents you provide in support of your application are legit, authentic, and original. original, credible, and things like that. So do not be caught up in misrepresenting facts. Do not be caught up in providing fraudulent documents or anything of the sort. This application must be done carefully, must be done sincerely, and not abusive of the pathway that Canada has provided to permanent residents in this case. So I'll switch that over to Irony, given the time that we spent so far.
So we want to thank you all for joining us, and we hope that we have provided clearance where there's doubt, and you have clarity now in terms of putting together your application. Again, we would say that you should reach out to your lawyers and let them provide specific legal opinion to you regarding your applications. Once again, thank you again for joining us. We look forward to connecting with you at some other point. And if you have any other questions or inquiry, you can always shoot us an email at info@tpmattorneys.com. You can also follow us on our social media pages. We're on YouTube, Instagram, all the social media. I'm sure, okay, those are going up now. You can see them in the chat: Facebook, Twitter, Instagram, LinkedIn, and YouTube. And you can also send us an email or give us a call. Thank you again for joining us, and we hope you have a pleasant rest of the day. Thank you.
Thank you, everybody.